Hello, and thank you for joining us. I'm Etta Baker, Housing Navigation Specialist for the African American Alliance for Homeownership. This webinar is brought to you by the African American Alliance in partnership with the Commons Law Center and funded by the Portland Housing Bureau. The African American Alliance is a HUD-approved, non-profit, community-based organization whose mission is to increase homeownership and economic stability for African Americans and other underserved individuals by improving access to home buyer resources and education. This webinar is a principled opportunity aimed at legally ensuring your final decisions regarding personal and other asset preservation distribution. If you want to know more about and this program, contact us, visit us at www.ah.org. Thank you and welcome.
Thank you, Ms. Etta.
Yes, thank you.
All right, thank you. Good afternoon, everyone. We are so glad you could attend this webinar on estate planning and hope you're in good health and lifted spirits while we tackle this current pandemic. I know it's been real hard for everybody. At the very least, I hope we can ease your minds about how to protect yourself and your family with the basic estate planning tools that we're going to cover with you today. Let me introduce myself. My name is Akua Hackman, and I work for the Commons Law Center as the lead attorney working on the Homeownership Asset Preservation Program. This program is designed to provide free estate planning services to qualifying families in North and Northeast Portland with the goal of combating gentrification and building intergenerational wealth. Thank you for coming, and I'm going to let Rebecca and Amanda introduce themselves.
Hi, I'm Rebecca Gandy, and I am an attorney just helping out with answering some questions that may come up because I've been in practice for about 7 years doing estate planning out here in East Multnomah County.
Amanda, I think you're on mute.
I'm so sorry. And I'm Amanda Caffel, Executive Director at the Commons Law Center. And thank you, Etta and Rebecca, for being here with us today.
All right. So this webinar is designed to educate you with the basics of estate planning. We'll talk about the current status of wealth in the United States, why estate planning matters, common reasons why people don't create an estate plan, and then give an overview of a few basic estate planning documents and their purpose. As I'm covering these topics, please feel free to submit your questions to the Q&A feature at the bottom of your screen so that we can answer them at the end of the webinar. We will start by answering questions that seem to be showing up the most common questions, and then we'll answer any related questions before our hour is up. Before we get started, I need to remind you that this is general legal information meant to educate, not legal advice. Rebecca and I and Amanda are not your lawyers providing this legal information, just providing legal education. That being said, let's dive in. So it's no surprise that the wealth gap in this country has been steadily increasing with more money concentrated in fewer people. And it may not even surprise you to know that communities of color are unequally impacted by this widening gap. In 2016, the wealth of a white family was 7 times greater than that of a Black family and 5 times greater than that of a Hispanic family. But did you know that home ownership accounts for about 1/4 of all that wealth? That's especially true for communities of color. 54% of wealth in the Black community is tied to home equity. Since most of the community's wealth is attached to homes, the same people would be most impacted by the loss of homes. According to a study done by PSU and the Coalition for Communities of Color, Black family income in Multnomah County is less than half that of white families. And the poverty rate among Black children is about 50%, compared to 13% for white children. Additionally, fewer than 1/3 of Black households own their homes, compared to 60% of white households in Multnomah County. Black folks have experienced housing displacement and the loss of community as the historic Albina district has gentrified. Now let's take a good look at this figure. Over the last century, the Black community has lost nearly 3.8 million acres of land, valued about $6 billion, in part due to people dying without a will and the estate selling off and dividing that property. The state keeps the proceeds of those sales when there is no will and the heirs of the person who passed away aren't found. Estate planning can safeguard the wealth and the assets and ensure that they stay within the family. 53% of white adults have wills, while only about 28% of non-white adults have wills. Even though proper estate planning can ensure that preserve this type of intergenerational wealth, 58% of adults ages 53 to 71 do not have a will. The percentage of people with wills varies among different socioeconomic and racial groups. Only 31% of people with a household income of less than $30,000 will have a will, while 55% of people above an income of $75,000 do. White families are 5 times more likely to inherit from deceased loved ones than Black families are. As this suggests, the Black community does not always benefit from inherited wealth as other groups. As we will learn, estate planning facilitates the transfer of wealth from one generation to the next by passing on money, personal property, and homes. So with that background in mind, let's talk about why estate planning matters. Estate planning can accomplish many goals. It can streamline the transfer of property from one generation to the next. Estate planning allows you to pass down assets unequally among children if you wish. You can pass them directly to grandchildren, or you can make gifts to other important people or charities in your life. Proper planning also ensures economic assets stay within the community. You can make sure your children and grandchildren do not have to start from scratch. Not having a plan in place can lead to dealing with unexpected parties and costs, along with no control over who inherits or where your property goes after you pass on. Families with modest means can least afford the consequences of dying without a plan. Not only does planning give the immediate beneficiary the benefit of the money inherited, but it also keeps the assets in the community and prevents them from being sold off and people forced to move out of family homes. Even knowing the importance of estate planning, many people don't create a plan. Why not? Some common reasons for people not creating an estate plan include assumptions that the assets will automatically be passed down after death, assuming that someone will inherit a piece of property just because they are a family member or currently live in grandma's house, distrust of the legal system, inability to afford legal services, the belief that estate planning is only for wealthy people who have a lot of money or items to pass on. And the biggest reason people don't create an estate plan is procrastination. It's easy to think that you'll get to it someday or that you aren't elderly, so it isn't important to worry about right now. But being prepared, regardless of your stage in life, is essential to ensure your wishes are carried out and your family is cared for after you pass away. Now that you know about the current status of wealth, why estate planning is important, and why many people still don't create estate plans, you might be wondering, well, what exactly is estate planning? Estates are not just for rich folks. An estate is all of the property you own individually or jointly with another person like your spouse. This includes real estate, vehicles, bank and retirement accounts, jewelry, and even pets. An estate plan is a legal set of documents that describes what you want to happen to that property after you die, who you want to be in charge of making sure those wishes are carried out, and what happens if you become incapacitated while you are alive. There are a handful of basic estate planning tools that can help you accomplish your goals. They include your last will and testament, irrevocable living trust, a power of attorney, or a financial power of attorney, and a healthcare advance directive, sometimes called a medical power of attorney. You'll have to excuse some of the background noise. The first document we are going to talk about is a will. A will is a legal document that becomes effective only when someone dies. It explains who will be in charge of your estate, how your final expenses will be paid, and who will inherit your property and assets after your death. Earlier, we talked about how few people actually create estate plans, so why is having a will specifically important? Wills give you control over what happens after you die. When a person dies without a will, their property will pass by Oregon law. For example, if you die without a will and you have a spouse and kids from a previous marriage, the assets are then split between that surviving spouse and those kids from the previous marriage. Scenarios like this are an example of how these laws may or may not mirror how you want your property to be distributed, which is why it is usually better to have a will. Wills can serve a few more important purposes. As I stated before, a will allows you to leave your assets to whomever you want in the way you want when you pass away. Another benefit to creating a will is that it allows you to name a guardian to care for your kids. Even if you do not have many assets to plan for, naming a guardian is one of the most important reasons that a parent would still want to have a will. In your will, you also name someone to be in charge of your will, called a personal representative, or commonly known as an executor or administrator. The personal representative is responsible for carrying out your last wishes and making sure your final affairs are taken care of. It also might be a good idea to name an alternate personal representative in the event that the first person you choose is unable to serve. This is an important role, so you really should talk with your loved ones and make sure whomever you appoint is willing and able to carry out your wishes. If you have a will, can you avoid probate? The short answer is no. Having a will does not necessarily help you avoid probate, but having a will can reduce the cost of probate and the burden to your family and friends. Whether your property needs to go through a long and complicated probate is determined by the value of the property and how that property is titled, not by whether you have a will. I know I just mentioned probate, and not everyone necessarily knows what probate is, so let's briefly talk about it. Probate is a formal court process that notifies potential creditors and heirs of your death, confirms that your debts and final expenses are paid, and transfers title or ownership of your assets. Leaving an estate plan can help avoid the process of the court having to locate your heirs, also reducing the time and cost spent on probate. Another way to protect and maintain control over your assets is through a revocable living trust. A trust is like a bucket that you put all of your assets into during your lifetime. The trust or bucket becomes the owner of those assets. Probate is typically not retired as long as those assets are properly titled as owned by the trust. You remain in control of those assets during your lifetime, but when you become incapacitated or pass away, a third party, known as a successor trustee, automatically steps up and takes over managing the trust and making distributions based on the instructions left in that trust. The successor trustee is a person that you choose. Here you can also name an alternate successor trustee in the event that the first person is unable to serve. A trust is also helpful when beneficiaries are minors or at risk of misusing funds, such as to support an addiction. Having a revocable living trust can help with incapacity planning like a power of attorney or an advance directive, which I will discuss in greater detail next. The next document that can help you achieve your estate planning goals is called a power of attorney. There are two forms of power of attorney, financial and medical. First, we will discuss the financial power of attorney. A financial power of attorney does not refer to an attorney's legal authority. Instead, it refers to, it's basically a planning tool that protects your assets while you are alive. Setting up this document is helpful when you are alive but unable to manage your bills or understand your finances. Going forward, we'll use the term incapacitated as a shorthand for when you're unable to take care of yourself. A power of attorney has two parties, a principal and an agent. The principal is you, the person creating the power of attorney and appointing someone you trust to manage your money and property. The agent is the person you choose to manage your assets while you are incapacitated. The agent can be anyone over the age of 18 who isn't incapacitated themselves. Typically, you'd want to talk to the agent beforehand to ensure they're willing and able to act as your agent. and that they understand your instructions and priorities in case the need to use the power of attorney arises. It's also a good idea to choose someone who is good with money. If this person has a history of being careless or reckless with money, maybe take a little extra time to consider someone else to serve in this role. You may wish to name an alternate person in the event the first person is also unable to serve in this role. The financial power of attorney can be drafted to kick in the moment the document is signed, so right away, or it can take effect when you are officially declared incapacitated by a doctor. At that point, the person you appoint to be your agent steps into your shoes and acts on your behalf and for your benefit. The agent's powers include typical financial transactions such as paying bills for you, selling property as needed to pay for your care, filing taxes, and any other instructions you've listed. Your agent's authority can be as limited or as broad as you need it to be. This includes limiting their authority to one bank account or giving the agent the authority to manage your finances temporarily while you're out of the state or the country. Powers of attorney are flexible, so remember it's up to you. Your agent's authority over assets will end when you revoke the power in writing or upon your death. If you are unable to manage your financial affairs and don't have a power of attorney set up, your family may have to have the court appoint someone to manage your finances, commonly called a conservator. The conservator plays the exact same role as the agent, but they're appointed by the court instead of by you. If you end up needing a conservator, your family will have to pay for an attorney, deal with the court system and possible delays and invasions of privacy. And this process can be confusing and time-consuming, and also expensive. So it's worthwhile to put a plan in place ahead of time, even if you never end up needing it. Bottom line is having a power of attorney can help avoid the need for a conservatorship. As we switch to talking about the Healthcare Advance Directive, or the medical power of attorney, I wanted to share a few important statistics with you. According to the American Bar Association, Black elders are less likely to receive hospice or other comfort care at the end of life, and are less likely to have their pain effectively managed. Did you also realize that we tend to have the lowest rates of advanced care planning nationwide? This includes planning for elderly care and end-of-life decisions. This to me is outrageous. Explanations for the low rates of advanced care planning among Black elders include the mistrust of doctors and the healthcare system, very valid and very real. Religious beliefs, unwillingness to acknowledge a terminal diagnosis or outcome, greater desire for life-sustaining treatment, low health literacy or the ability to read and understand health information, and sincere doubts about the effectiveness of advanced care planning. With that in mind, let's really take a good look at the Advance Directive. An Advance Directive is the term used in Oregon for the legal document that creates a medical power of attorney. This form allows you to make it clear what you would like to happen with your medical care if you ever become so sick that you're not able to speak for yourself. This document ensures that your medical needs and care are guided by your wishes. In the Advance Directive, you appoint a health care representative who will make the decisions regarding your medical care. Your health care representative can advocate for you in a medical situation. For that reason, you should select someone who is willing to serve in this role, who you trust to follow your wishes. Here, you have the ability to name alternates in the event that the person you serve is unable to serve. So when choosing your healthcare representative, there are a few important factors to consider. First, is the person playing this role assertive? Keep in mind that your agent may have to fight to assert your wishes in the face of a stubborn medical establishment and against the wishes of family members who may be driven by their own beliefs and interests rather than yours. If you foresee the possibility of a conflict in enforcing your wishes, be sure to choose an agent who is strong-willed and assertive. Second, does this person live close to you? While you don't have to necessarily pick someone who lives in the same city or state as you, location can be critical. If you have a long illness, Your agent may be called upon to spend weeks or even months nearby, making sure that medical personnel abide by your wishes for healthcare. And third, will the person also be your financial agent? If you make a power of attorney to name someone to manage your finances, you may consider naming the same person as both your agent for healthcare and for finances. If you feel that you must name different people, be sure that you name agents who get along really well together and who can work together. If you wouldn't want, for example, your agent for finances to interfere with your healthcare wishes by stalling or resisting payment of medical insurance bills, two things over which your agent for finances will most likely have control. There are several medical decisions that can be addressed by an advance directive. Here we have listed some of the typical situations you'd be answering in the advance directive to help guide your care. These situations include resuscitation, mechanical ventilation, tube feeding, comfort or hospice care, organ and tissue donation, and donating your body to science. You are also given the opportunity to include any religious preference to help guide your care. So it might be uncomfortable to talk about these things, but it's so important to have a conversation with your loved ones about what you would want in case you're unable to communicate with your doctor. Most people will reach a point in life where they can no longer speak for themselves. No one can predict when that will happen, but they can happen whether you are young or old. When this happens, doctors hope to provide the treatment that you would want, but your wishes aren't always clear. With an advance directive, you make it clear what your wishes are and potentially avoid a great deal of family tension and conflict. After you have your advance directive set up, it's a good idea to give a copy to your doctor and your healthcare representative. Because you might change or update your advance directive in the future, it's also a good idea to keep track of who receives a copy. Review your advanced care planning decisions from time to time because you might want to revise your preferences for care if your situation changes. For example, you might want to make adjustments if you receive a serious diagnosis, if you get married, separated, or divorced, if your spouse passes away, or if something happens to your healthcare representative, you'll want to appoint a new one. If your preferences change, you want to make sure your doctor, your healthcare representative, and your family know about them. Planning for the worst case scenario can be incredibly hard, but it is essential. Before we close, I wanted to mention a few other tools that can help you avoid probate and make sure your assets go where you want them to go. One choice is joint ownership. It provides a simple and easy way of avoiding probate when the first owner dies. To avoid probate, you would take a title as joint owners with somebody else. For instance, probably your spouse. And you would use a real estate deed and name that person on paper and name how you would want to hold title. Usually no additional documents are needed. One other option is payable on death bank accounts. They offer another easy way to stay out of probate. All you need to do is fill out a simple form provided by your bank, naming the person who you want to inherit the money in your account at your death. As long as you are alive, the person you name to inherit the money in a payable on death account has no rights to it. You can spend the money, name a different beneficiary, or close the account while you are alive. At your passing, the beneficiary just goes to the bank, shows proof of death and proof of his or her identity, and then collects whatever funds are in the account. No probate court is involved. Now, if you and your spouse have a joint account, when the first spouse dies, the funds in the account will probably become the property of the surviving spouse. No probate. If you add a pay on death designation, it will take effect only when the spouse passes away, the second spouse passes away. These rules are similar for a transfer on death account. You can leave stocks, brokerage accounts, or bonds without having to pass through probate. This works like a pay on death account where you register your ownership and then designate the beneficiary. Beneficiary designations also involve retirement or life insurance policies. As you know, when you open a retirement plan, such as an IRA or a 401k, the forms you fill out will ask you to name a beneficiary. After your death, whatever funds are left in the account will not have to go through probate. The beneficiary you name can claim the money directly from the account. If you're single, you're free to choose whomever you want as the beneficiary. If you're married, your spouse will have rights to some or all of the money. Congratulations, now you know the basic tools of estate planning, and in this webinar we have covered the current status of wealth in this country and in Multnomah County, what estate planning is, and the basic documents to help you achieve your goals. Thank you for listening, and now we're going to open the floor to some questions. I'm going to look at the question Q&A box right now. Well, if there are no questions, maybe we'll wait a few seconds.
Akua, what are some of these documents that people could do themselves, and which ones do they need maybe help with an attorney?
All right. A document that you can do yourself is an advance directive. All you would have to do is fill out the instructions left in the form and make sure people know exactly what you're looking for. The one part that you can't do yourself is notarizing. You need a public notary to help you formalize that document. You can probably also do a power of attorney, but there is a risk with the power of attorney. If you were to look on a website like LegalZoom, those instructions are baked into the form. You can't really change what the instructions are in them, and it would be helpful. Sometimes it would be dangerous in some cases to not be able to change the instructions to fit your situation. You might bring more trouble on yourself than you would want. So I'd say for a power of attorney, unless your instructions match that already put into the form, I would be very careful about doing that one by yourself. But I'd say for healthcare, the advance directive is probably a good idea to get that one done.
So, can you hear me, Akua?
Mm-hmm.
So here's a question. If, say you do a form by yourself, you know, you're able to do whatever, navigate, is it best to still have an attorney review it before you call it formal?
I would say yes. Some of these forms, like I said, for a person who doesn't necessarily understand the language in the form, if you sign it, you notarize it, it may have unintended effects. That's why I think it's a very good idea to have someone read it over for you and answer any questions you may have about the form and the effect of the form once you sign it. Rebecca, any other feedback you think?
No, I definitely would agree. I'd say the advance directive comes with some instructions, and your doctor also can help you with some of the explanations. But the power of attorney that you might see, for example, as you were saying on the internet, is sort of like a recipe, and it may or may not fit your needs. You might be gluten intolerant or whatever, not able to follow that recipe. I guess that's what I'm trying to say as an analogy. But your power of attorney, you might want to pick and choose among the different powers you want to give that agent. And that's why it's helpful to have an attorney explain to you what certain sections may mean.
Mm-hmm. Oh, I see another question. It says, if you are planning on moving to a different state in the future, would you need to change any of those documents after you have moved? And how would those documents get transferred? So each state has different laws. So I think you would have to get those forms done so that the laws for those documents.
I'm sitting. All
Sorry?
right. Did you want to sit back here?
No.
Rebecca, any other feedback?
Yeah, some of these documents are going to have full faith and credit when you go to another state, and they're going to look at those because the most important thing is that these documents reflect your wishes. So the new state would look at, say, for example, your will. Say you moved to Washington, they would look at your will and see what your wishes were. But the best practice is to redo your estate planning when you move, if you're going to move permanently, because there may be advantages and disadvantages to that new state's laws that you want to take advantage of.
Mm-hmm. So I see another question. Can you still take a will to probate even if you are the family member being left out? I would imagine so, yeah.
Yeah. That's a good question. Yeah, whoever files a case in probate, they state the reason why they think they should be made the personal representative of the person. The person who's named in the will is going to have some priority over them unless you could show that there was some undue influence or other fraud involved in the making of the will. So I'd say in that kind of a situation, if you felt like, hey, this isn't really my family member's will and this isn't the right thing, you could intervene in court, but that's kind of a complicated situation you'd want to talk to an attorney about.
All right, I don't know if I'm seeing any more questions right now.
I think we're good.
Okay.
While we're waiting for a few more questions, I'd like to interject and apologize for the technical difficulties that we encountered today. We've recorded the webinar. If you missed any part of it, we will send it to you. And we'll also be repeating this webinar in August and have ideas for a couple of potential follow-ups to answer more questions about estate planning.
Oh, it looks like we have a couple more questions.
Okay. So it says, if a spouse dies, how does the living spouse get the spouse that died off of title for the house?
Well, if the spouses own the house as husband and wife, then typically you would go to that county and file in that county the death record, which is what we call the death certificate now. And that will in effect change the title, though you can also then redo a deed and file that as well.
Okay.
Because husbands and wife are assumed, if they're both on the title, to own it together in joint ownership. Like Akua was explaining, it goes automatically. It does not have to go through probate if you have joint ownership with survivorship.
Okay.
Did that make sense?
Made sense to me, but if anyone has any questions after this webinar, you can feel free to give us a call at this number listed on the slide right here. We can talk some more. Now, if there are no other questions, then okay. If there are no other questions, I think we'll close for the day, and we'll do this again in August. And if anyone else has any further questions to ask, we can talk some more. Now, Cheryl, did you have anything to add?
No, I don't. Thank you.
Thank you very much. Thank you for coming, and I'm happy to do this again next month and try to get all your questions in then. All right, everybody, thank you so much for coming.